The defense sentencing memorandum makes arguments that use the defendant's gender as a basis. That memo argues prison is not safe for transgender people, that prison cannot allow Smith to navigate her gender identity. That I have two main responses. One, it is ridiculous and without evidence that the Wisconsin prison system cannot accommodate transgender people. It can and it does. The prisons are safe, probably safer than outside the prison because of all the supervision and control of inmates. This is a perpetuation of movie stereotypes that is wrong and harmful. Second, it's illegal for courts to consider gender as a sentencing factor in Wisconsin. It is categorically an improper sentencing factor, just like race or religion. The Supreme Court of Wisconsin explicitly held that gender cannot be considered in State v. Harris, 2010 WI 79.
All right, so I'm going to start with you, Mr. Schmidt, sentencing recommendation and argument.
Thank you. State's going to be recommending the court follow the Department of Corrections recommendation. The court should order 1.5 in, 2 out on the fleeing, should order 3 in, 4 out on the reckless. Those counts should be concurrent to each other because they were part and parcel of the same action or series of acts on the same day. They described the same conduct. They should be consecutive to any other sentence in Wisconsin or Minnesota because they are distinct acts in a distinct state. I start first with explaining why probation should be rejected. First off, this is Smith committing their third fleeing offense. They have 1 prior criminal conviction for it and 1 prior adjudication of delinquency for it. This offense was committed while on supervision for one of the fleeing offenses. Probation is a consequence for a crime that you're already on probation for and you do it again it's nonsensical. That is the clearest sign that probation unduly depreciates the seriousness of the offense. Furthermore, Smith's history clearly demonstrates that they're just not amenable to supervision at all. At age 25, Smith has 10 prior criminal convictions, counting these 2 today, and 9 prior juvenile adjudications for crime. That's 19 convictions or adjudications over only 13 years. When you go down and read through that sentencing, what do you see? In the criminal cases, you see probation ordered every single time, 8 times convicted prior to today. Smith was given 8 orders of probation. Smith has persuaded adult courts to place them on probation every single time. 8 times Smith has been ordered, to work with agents, to deal with substance abuse, to deal with mental health, to deal with cognitive issues. 8 times it's failed. CCAP and MCRO are useful in figuring out why. And that's because Smith simply doesn't participate unless they're physically forced to. MCRO and CCAP show countless failed court appearances while the cases are ongoing and probation violations once they've concluded. Smith's own stated reason in our case for fleeing the police was to avoid those consequences. Smith had 3 different Minnesota warrants out for her arrest when this fleeing happened. In our own case, even, it took 4 warrants across 3 years to force Smith here to this table at this moment. The court gave Smith a big leap of faith when it allowed her to stay out and go to that treatment facility while waiting for the PSI. And Smith demonstrated why she's not amenable to supervision when she didn't come back when she absconded. As a result, probation is not appropriate for this offender. There's no reason to think that she will comply when there's a decade of history telling us otherwise. Smith needs treatment, and this needs to happen in a confined setting. I find it strange that Smith related to the PSI writer that they didn't believe incarceration is effective at changing people's behavior because, like I said, Smith's effectively been on some form of supervision for 13 years, going way back into her childhood. She's not been given incarceration. So to conclude it's not effective when what you're asking for has itself not been effective doesn't make a ton of sense. It should be no wonder that Smith has continued unabated in her behavior because she's simply not been held accountable. The only time she's gotten incarceration, it's been as a revocation or a DOC action for noncompliance. When treatment fails, when cognition is contaminated with what I kind of view in the PSI and the offender's version of, what happened and what to do next and what their goals are, it reads like me. It reads like somebody who isn't thinking about rejoining society for the purpose of helping others or feeling bad about the victims in their cases. To that end, that's why you need specific deterrence in cases like this. If you have an offender where those drivers that we usually rely upon for people to modify their behavior, empathy, consciousness of guilt, just feeling bad for your own actions is how I describe them. Those things you hope that get instilled in children at a young age. When those aren't happening, when they've already had all the attempts being on supervision, whether probation or court supervision, where they've had the option of going to treatment centers and having doctors and having agents with them to work on them to accomplish conditions of supervision. When that just fails over and over, that's when you need specific deterrence. That's when somebody isn't being motivated by the carrot, so they need to be motivated by the stick. And this is one of those cases. It also leads me to general deterrence and punishment. As I said previously, this is the third time that Smith has been either convicted criminally or adjudicated delinquent of fleeing. This fleeing involved throwing large objects into the road. One of them was described to me by Deputy Moe as like a metal ramp that sparked as it hit the road. Deputy Moe said that Smith threw it into the middle of the road and he had to make an abrupt movement to avoid it. If he had made a mistake, if he had not reacted quickly enough, one of these objects could have been struck by him or a different police officer at the speeds they were going. They could have died. That's the essence of what the reckless is. The reckless is creating a risk of death or great bodily harm. In this case, it was to a police officer just doing his job, trying to arrest Smith on a warrant that resulted from her own behavior, from not cooperating with supervision over in Minnesota. Smith admitted they were fleeing to avoid consequences and said she was high on meth while fleeing. That reckless conviction exists because the way Smith chose to go about fleeing this time was so much more dangerous than a typical fleeing we see in this county, than her past fleeings. Other people in the public have to be deterred, and quite frankly, the need for punishment is the reason why the recommendation here for a high-end fleeing sentence and a mid-range reckless sentence is being recommended, because the gravity of this offense, the way the reckless and the fleeing exacerbate each other, aggravate each other, is the reason why. This was a fleeing where the driver's speed was high. It varied between 40 and 69 miles per hour, where Smith would only slow down when throwing objects out of the vehicle. She blew stop signs. She crossed the center line. The vehicle only stopped because Smith disabled it herself while trying to get into the ditch to avoid a spike strip. Smith fled on foot afterwards after the vehicle wouldn't move anymore. Chase was over 10 miles. And it's a chase that endangered the deputies, as I described before, with the throwing of objects. This is not a young first-time offender who made a one-off mistake, who acted outside of character because of some underlying issue that heretofore has never been addressed before and is easily fixed. This is a 25-year-old person who has, despite 13 years of some help, some supervision, some court conditions, has continued to be a risk to the community, has been escalating in the risk to the community with this fleeing, who continues to ignore supervision and rules of courts. The courts have uniformly given Smith up to this point second, third, fourth, eighth chances, and now Smith is asking for a 19th one if you count the adjudications. McCleary-Gallion factors demand more. The character of this offender is such that prison is necessary. Probation would unduly depreciate the seriousness of this offense, and the court should follow the recommendation of 1.5 in, 2 out on the fleeing, and 3 and 4 out on the reckless. Finally, there's one thing I do need to comment on from the sentencing memorandum that I have a serious problem with. The defense sentencing memorandum makes arguments that use the defendant's gender as a basis. That memo argues prison is not safe for transgender people, that prison cannot allow Smith to navigate her gender identity. That I have 2 main responses. One, it is ridiculous and without evidence that the Wisconsin prison system cannot accommodate transgender people. It can and it does. The prisons are safe, probably safer than outside the prison because of all the supervision and control of inmates. This is a perpetuation of movie stereotypes that is wrong and harmful. Second, it's illegal for courts to consider gender as a sentencing factor in Wisconsin. It is categorically an improper sentencing factor, just like race or religion. The Supreme Court of Wisconsin explicitly held that gender cannot be considered in State v. Harris, 2010 WI 79. Any argument based upon Smith's gender should be disregarded by this court. It has no application to sentencing in Wisconsin. Thank you.
All right, thank you. And it's my understanding that Josie is still on supervision from the latest Minnesota conviction from June.
I believe so, Your Honor.
At least that's what the PSI is stating, and no one corrected me. All right, thank you. Argument and sentencing recommendation, please.
Thank you, Your Honor. I think certainly when we look at this situation, it is quite serious. It would be quite serious if it was a first-time offense. It is certainly serious as it is now. It involves a high-speed chase with law enforcement over several miles, at which point several items were thrown out of the window. It is serious. And I don't think that Josie is under any impression otherwise. In discussing this case with her, Your Honor, and discussing this sentencing, it's been very clear, been made very clear to me that she understands that this is the last stop. There are no further chances that are going to be coming after this. Her record is quite long. It involves serious offenses. It involves offenses of a repeated like nature. She understands that after this point, frankly, since she's been an adult, and arguably before, there are responsibilities towards participating in society that she has not upheld. She's engaged in antisocial behavior and has received punishment to that effect. She has been put on supervision, as has been noted by the state. She has been revoked off that supervision multiple times in Minnesota. In fact, in looking through the packet and looking through the length of this case, it seems there were some significant periods of time in which she was serving out revoked sentences in Minnesota. I say all that, Your Honor, because I think the state's perspective on Ms. Smith is that she's someone that doesn't get it. She's someone that hasn't been able to get it. But in speaking with her and in discussing this case with her, Your Honor, I do believe that thankfully now finally has come the time where she understands that this behavior cannot, should not, and will not continue. She understands and is very open to me about the remorse that she feels for the situation. It's regrettable that it ever got to that point to begin with. But I think looking at that situation, Your Honor, and then looking at Ms. Smith's adult history, I think there is a clear through line here, and that clear through line is substance use. She's advised, and as was outlined in the defendant's memorandum, substance use has been a factor in Josie's life from a very young age. She was exposed to and given substances by people that she should have trusted. And I say should have trusted, Your Honor, because these were not people that she actually should have trusted, but she should have been able to trust them because these were people in her life, authority figures, family, who should have been there to look out for her, to look out for her going on the path that has led her up to this point and acted to steer her away from that. Now, I certainly don't think that that makes for an excuse, Your Honor. I don't think that that justifies what happened here or what has happened in the course of Ms. Smith's life. But I do think when we look at her character, her conduct overall, the reason that she is coming back before the court, that she is having difficulties in adjusting to supervision, the reason that she is getting new court cases is because of this underlying issue. I think thankfully, Your Honor, this last period of incarceration has in some ways been a blessing for Ms. Smith. It has been a period of enforced sobriety for her. It's been a period where she's been able to clear her mind and really understand the gravity of what has happened here, the gravity of what's occurred over the course of her life, in this case so far, and what she needs to do to avoid that going forward. As a member of the Mille Lacs Band in Minnesota, Your Honor, Ms. Smith is again, in somewhat of a lucky position. She has access through her connection with that community to resources that frankly make the resources that someone else in that community pale in consideration. There's simply more funding, more programming that's available for her as a member of that tribe. So I think looking at the situation overall, Your Honor, looking at the reason why Ms. Smith keeps on coming before the court, the reason why she keeps having these issues in adjusting to supervision is by and large from an inability to address and move forward from an issue of substances with narcotics.
Dear Judge Mogan, I'd like to start off by saying how sorry I am for my part in taking so long to realize how much time it's taken to get this case settled. I realized that I've made so many mistakes that I cannot change, but learn from it. I've been so hard on myself, and I know that just because of my past doesn't mean it's too late to change my future. I have so much to live for and do with myself instead of repeating past behaviors. I've learned that no one will or would judge me if I have to ask for help. I've always thought about others. People treated me different if they saw or knew that I needed help. But truth be told, it shouldn't matter to them because they don't know my whole story. And it doesn't matter what they think. I struggle and I struggle, but knowing or by thinking I know how to help myself, I didn't. I know now that maybe it's better if I get help from someone professional, or just maybe I can have the chance to get a better outcome. I've had some time to think of a plan for when I get out. I have plenty of resources and structure and people to stand by me and help me get through this that I didn't realize I had, and I don't have to go through this alone. I also understand that this is a serious and take full accountability for my actions. I didn't intend on hurting anyone but by my actions. I do see now that I could have, anyone including myself could have been seriously hurt. I don't like knowing that I was the person putting others in danger. I hope you know that I'm really sorry for my actions in putting the police officers and myself in danger. I've learned a lesson that by the path I was going down would not end well for me, and that it's not too late to take a better one. As soon as I get out, I also plan on seeking help for my mental health. For my depression, I plan on seeing if there are medications that can help with my mental health. I know that things like medications take time to start working, but I like to start somewhere.
You have to work through those, and you have to start with going to the healing center, working through your traumas, discussing what you are experiencing and feeling today as Josie, all right? And that kind of situation before you can change yourself. And you did hit it, the hammer right on the nail when you were stating that, you know, maybe I can change the people that I hang around with, and I probably should. Because Josie, you have to change your habits and the things that you do, and you have to change your associates, the people that you hang out with, in order so you can change yourself. You have to be able to do that. That's where you start, changing your habits and the things you do, and changing the people that you give yourself to, you give your time to, your energy to. That's the only way you're going to significantly improve your life. And if you don't modify and make those changes, I hate to see where you're going to be in 5 or 10 years. I hate to see that. The court has to look at the seriousness of the allegations, the nature and gravity of the offenses here. And the court looks at all of the charges that were dismissed and read in, including the charges that you were convicted of, and to see whether or not there's an aggravation there. And there is, with all of these felonies and all of these serious crimes and the conduct that you engaged in, it does aggravate it. I have to look at your character, your past criminal record. I have to look at needs for your rehabilitation and protection of the public. And as Mr. Schmidt touched on, I have to look at this thing called deterrence. So what sentence is going to finally deter Josie from continuing down this path? And what sentence is going to deter others from doing similar things? Because if the court were to look at a lesser sentence, a smaller sentence than what's recommended here, well, let's say a very small sentence. We'll start at the short end of what defense argued, 110 days, concurrent with each other, but consecutive with any other sentence. If the court were to look at a sentence structure that is that small with the actions here, it would unduly depreciate the seriousness of the offense, and it would not deter others from doing this. Because if we look at this, the charges alone that you pled guilty to and you're convicted of, that was extremely serious. Speeding down a roadway, a highway in Burnett County, and throwing things out of the car to try and evade and flee the officers. Where Mr. Schmidt made a very good point that if something were to be thrown out of the vehicle and were to hit the officer's car going at a high rate of speed, anything could happen. The officer could swerve and hit a pedestrian, could hit a different vehicle, could hit a house. The officer could die. Innocent people could have died because of your actions and conduct that day. So that's where the court has to look. Are we looking at a punishment in the lower end, or are we looking at the higher end of a sentencing? This is serious. And it should deter not only you, but it should also deter others from thinking that this conduct and this behavior and doing these things is okay. The court will not look at probation. I have looked at it first, but I will not order probation because, as I stated, it would unduly depreciate the seriousness of the offense. So the court has to determine, is this going to be a straight out jail sentence, or is this a necessary prison sentence where you need more structured supervision and someone else from Minnesota, because you're not from here, so you would be asking to have, through the interstate compact, your probation or extended supervision in Minnesota, but to have somebody else oversee you to make sure you're doing what you need to do. Josie, you're in the driver's seat. You're in control. You have to make those choices and those decisions. You have to. You are at this age where your brain is finally starting to fully develop, and you're starting to be able to think like an adult. You have to now start thinking clearly. Is this where you want to be in 2 more years, Josie?
No, I
you don't. Is this where you want to be in 5 years or 10 years? Or is this where you want to see your friends or your family in something, in a chair right there,
No, I
waiting
don't.
to determine if you're going to go to prison?
No.
In front of the court, you have appeared that you have a kind and gentle soul, demeanor, but you are letting your internal demons destroy you. You are. I do understand you've had a lot of trauma in your life. I've read it in the black and white, and I've heard some from you throughout these years. You can't let the trauma continue to dictate and to control your life. You have to do that. You do need some kind of treatment. And you do need to take that seriously. But again, only you get to make that choice. I have to look at protecting the public. And here, quite honestly, in my view of protecting the public, it's protecting Burnett County, the residents of Burnett County, and then I guess bleeding over to all of Wisconsin or there. And I know you have connections with Sawyer County, you have connections with Burnett, probably through family in both areas. But I do need to look at protecting the public. And so that's where the juggling comes in of, do I look at a lesser sentence, or do I look at all the way to the maximum possible penalty? But I have to look at a sentence that is minimal enough to deter you and to look at the seriousness of the crime without going beyond and being too harsh. Now, in reading the pre-sentence investigation report and hearing the argument of the state, it makes a lot of sense. Look at what you've been doing. You have continued to engage in these serious crimes. You've been to prison. You're not being held accountable. You're not taking responsibility. You continue to let your life be taken over by other people and their choices instead of making your own choices. So a prison sentence makes sense. However, there are other factors here as well. Your attorney did hit on some good things that you are finally in a place where you're realizing that you need to do something, or God forbid, you won't be around if you continue to engage in this type of behavior. Prison would be the least of your concerns. I don't want to see that, Josie. I don't want to see that. So I am looking at the middle ground of a sentence, something that would protect the public. It would address the seriousness of these offenses. It would look at your character and your past criminal needs and look at your need to rehabilitate, all right? And look at you as an individual person. So based upon that, what I am believing is an appropriate sentence. I don't believe that you need to have any continued contact with Burnett County. You don't need to have contact with Wisconsin. You can live your life and do what you need to in Minnesota, but you do need to be punished for your conduct and your behavior involved in this case and the 22 case. So what I am going to do is I'm not sending you to prison. So this is a blessing to you, Josie, right now. It is a blessing because you're going to get the punishment factor and the sanction factor, but you're also going to be able to figure out a life plan and follow that yellow brick road to what it is that you want to see your life be and for you to become. But I do think it is serious enough to sentence you to 1 year of jail, of county jail. Okay, 1 year. There will not be any ability to have the electronic monitor because I don't trust you. Sorry, I don't. And you're shaking your head up and down like
I understand.
It's there, right?
I understand.
So 1 year in the county jail, that gives you enough time to sit and to think and to figure it out. And it is consecutive to all other sentences. And it is each charge, each count has 1 year of jail concurrent to each other, but consecutive to any other sentence that you would be sitting, okay? $518 in fines and fees. I am also going to do a punishment factor on the financial end of it. $1,982 for each count in a fine. Because you failed to come to court, you failed to take care of this and handle this, and you missed court and absconded and were in custody somewhere else when you shouldn't have been, and the court did not even have to allow you to appear by video. But I believed you, Josie, when you said you want to make these changes and you want to do better. I believe you. But you have to grasp that hard and you have to take control and ownership of it. I can't want it for you more than you do. Mr. Felisky can't. No one in this courtroom can want it more than you because you're the one who has to do it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. No use or possession of a firearm for life, no voting in any election until your civil rights are restored. That does not include tribal elections. You have to speak with your tribe if you are having an election, whether or not they would permit you to continue to vote. I believe a lesser sentence would unduly depreciate the seriousness of the offense and it would not protect the public. And it's a punishment portion I believe That covers everything. Mr. Schmidt, what am I missing? Oh, 89 days of jail credit, 83 days of jail credit. No contact with Burnett. Don't come to Burnett, okay? Because if you're not doing well, I don't want to see you again,
I don't plan on.
but I want to know if you're doing well, okay? So, Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Felisky?
Nothing further. Thank you.
All right, then we are adjourned. Thank you.